All right. Good morning, everyone. I'd like to thank you all for joining us today. My name is Marcus Campbell. I'm an attorney with Miller Johnson. I've been attorney here for over 19 years. One of my specialties is unemployment. And today we're going to have a webinar to update you on the unemployment laws. And I received several questions in advance of the seminar. I've made sure that I incorporated those answers into the seminar. I will do my best to try to answer any questions that pop up as we're going along, but it might be a little difficult. I'm handling this solo today, but I will do my best to answer any questions that you have. All right, so I'd like to thank everybody for coming today. We appreciate when you attend these webinars. We want to make sure that we keep you informed of all of the legal changes, and there are many. With respect to unemployment, like I said, I've been doing this for over 19 years, and we've had more unemployment activity in the last 8 months than we've had in the last 19 and a half years. The unemployment system has changed substantially. I know we did about, I'd say at least 3 or 4 of these webinars early on after the CARES Act passed, but we've taken a little break, and the system has been trying to figure things out, and we thought it would be a good idea to update you and let you know exactly where the unemployment system stands. So on our agenda today, we're going to talk about the governor's executive orders and the legal saga and the impact that has on unemployment benefits. We're also going to talk about the current amount and length of weekly benefits. That, of course, has changed 3 or 4 times over the last few months. We're going to talk about COVID-19 related absences from work. I've been receiving a lot of questions from clients wondering whether or not my employees, due to COVID reasons, can't come to work for a week, can't come to work for 14 days, they have to quarantine. Are they going to get unemployment benefits? So we'll talk about those issues, and I'm going to provide some examples because I think that's the best way to clarify things, and I'll try to make them real-world examples. We're going to talk about work-share programs. Work-share programs, when the pandemic initially hit, were very, very big, and they're good programs. They are less popular right now because the additional benefits that employees were able to collect are no longer there, but still, they are very valuable programs, and they're great for avoiding layoffs and retaining your workforce, keeping your employees engaged. When they are coming to work at 50% of their normal schedule, as opposed to being completely laid off, you got a better chance of actually keeping that employee long-term and into the future. So the work-share programs are still good, and we will discuss those. We're going to talk about the fraud and identity theft problems. That is a big problem with the UIA now. We've never seen fraud and identity theft on this level. The UIA is taking some action to prevent that, but of course that is happening slowly. So they are working their way through it, but it is a major problem now. We're going to talk about contributing and reimbursing employer account charging problems. This relates to taxes if you're a contributing employer, or it relates to the reimbursements if you are, let's say, a nonprofit reimburser or a state and local government reimburser. There's issues at the unemployment agency about how your account is being charged. We're also going to talk about the reimbursing employer 50% credit under the CARES Act. There's a provision in the CARES Act that essentially gives a 50% discount to reimbursing employers. This is real money. Reimbursing employers pay dollar for dollar for unemployment benefits. So when they get charged $362, they have to pay the unemployment agency $362. They should be getting a discount of 50% on that. What I've been seeing from the reimbursing employers that I work with is that that is not happening. So we will discuss that as well. All right, let's get into the legal saga related to the executive orders. Now, during the pandemic, there were 4 executive orders that significantly impacted unemployment benefits from March 16th all the way through May 7th. Those were executive orders 10, 24, 57, and 76. They made a number of changes that allowed individuals who voluntarily left their employment, whether it's on a medical leave or they had to leave in order to take care of children because schools were closed, they allowed those individuals to get unemployment benefits. Normally, pre-pandemic, they would have been disqualified. That is a voluntary leaving. You do not get benefits when you voluntarily leave the workplace. So these changes were put in effect so that individuals could get benefits during this difficult time. They also modified the account charging issues. So essentially, there were executive orders out there saying employers should not be charged for anybody who was laid off or placed on leave of absence during the pandemic. So those executive orders were in place until the Michigan Supreme Court invalidated all of them. They issued a decision that indicated that all of those executive orders after April 30 were unconstitutional. So that left both the lawyers, individual unemployment claimants, everyone at a loss. We didn't know what to think. Are any of these orders still valid? Are there ones prior to April 30th valid? My personal opinion is probably not. It also left people wondering, well, are claimants going to have to pay back all of these benefits? If they were not initially entitled to these benefits except for that executive order, now that those executive orders are all gone, are 1 million laid off employees going to get a bill from the unemployment agency saying you need to pay these benefits back? Well, luckily, the legislature passed Public Act 229, effective October 20th. This is the first example in a long time of cooperation between the executive branch and the legislative branch, so it was very good to see. But what Public Act 229 did, it went into effect October 20th, and most of the relevant terms are retroactive all the way back to the date of the pandemic. But what Public Act 229 did was it made most of the unemployment changes in Executive Order 76 law. They are law at least up through the end of 2020. Once we get to January 1, 2021, we will have to reassess. But as of right now, the legislature stepped in, made the previous changes to unemployment law, and everything is going to continue as it normally was up through the end of the year. So they incorporated all the COVID-19 provisions that allowed people, even if you have to voluntarily leave work on your own because you have to quarantine, take care of kids, whatnot, it made those law. So those are in effect until the end of the year. Now, another issue that I've got a number of questions on is how much are employees going to get? Well, initially, when the CARES Act was passed back in March, there was the additional $600 per week that every employee got in addition to their state maximum of $362 if they qualified for the maximum, which a majority of employees do. So for a while, employees, laid off workers, were receiving $962 a week. That's over. That ended July 25th, and there was no congressional action to extend those benefits. So that is now gone. So as we stand right now, in the state of Michigan, the maximum that you can receive per week in unemployment is $362. Now, as of August, the president issued an executive order that authorized an additional $300 per week. And Michigan participated in that program. The money was distributed through FEMA to the unemployment agency, and then claimants were being paid. So there was a time where individuals could receive up to $662 a week. But that was only in effect for 6 weeks. FEMA had determined that there was only the additional $300. There was only enough money to cover 6 weeks. So that covered weeks of unemployment from July 26th through September 5th. So during those periods, individuals could get up to $662 a week. Now, those benefits are still being paid out. The UIA is drastically behind on claims. So individuals now are just starting to receive that additional $300 from the lost wages assistance. But technically, that is done. But some of those payments are still rolling in. So employees may be getting $662 a week, but it is not for this current week of unemployment. It's back from July 26th through September 5th. But now that additional $300 a week is also over. So currently, as we stand right now, if anybody is unemployed for a week starting today, it is $362 a week. That is the maximum benefit anyone can collect while they are on unemployment. Will that change? Boy, I don't know. I think so. We will have to see what happens in the election on November 3rd, and then afterwards, the Congress will have to take some action and change that benefit. My best guess is they probably will. Something will likely be done by the end of the year. I hope so, but we'll just have to wait and see. Currently, there are bills in Congress that they are fighting over. The Democrats' bill keeps the CARES Act additional $600 a week in place. There's a Republican bill that provides only $200 a week. There's another Republican bill that wants to gauge unemployment benefits on 70% of your wages so that you will get a check that amounts to 70% of your wages. So there are at least 3 solutions in the pipeline. We'll have to wait and see which one they agree on. All right, how long do the benefits last? That is a good question and a common question that I receive. Currently, right now, in the state of Michigan, you can receive unemployment benefits for up to 59 weeks. Under state law now, you get 26 weeks of state unemployment benefits, and then after that is exhausted, the CARES Act Pandemic Emergency Unemployment Compensation provides an additional 13 weeks. Now, that lasts until the end of the year as well. And then after that, there are 20 weeks of extended benefits. Extended benefits is a federal program that if a state's total unemployment rate rises to a certain level, I think in Michigan it's 8% or more, then extended benefits are triggered, and laid-off workers can receive those benefits. So as we stand right now, we're looking at a total of 59 weeks that can be collected on any unemployment claim. Now, of course, they must otherwise be qualified for benefits in order to receive these. All right. So with respect to the COVID-19 benefit issues, the changes in Public Act 229, let's discuss those. These are the changes that allow somebody who would otherwise not be able to collect benefits to collect them because it is a COVID-related absence. So the new law states that an unemployed individual is not disqualified if they left work voluntarily or took a medical leave of absence or took a normal leave of absence because, 1, the individual self-quarantined or self-isolated because he or she is immunocompromised. So if you can't come to work because you are immunocompromised, of course, the new law does not define what immunocompromised is. I think that the agency will take a very broad definition of that. Here's what I believe that they will say. If you have a medical condition that makes you more susceptible to COVID-19, then you can still get benefits if you can't come to work. You can quarantine and still receive those benefits. The second change, if the individual displayed a common symptom of COVID-19 that is not otherwise associated with another known medical condition. So if you have an individual that, let's say, has a fever, has to go home, stays home for a week, and can't work, eventually maybe they test negative, come back to work the following week, that individual will be able to collect unemployment benefits. They will not be disqualified for a voluntary leaving like they normally would have. Now, of course, if it's associated with another known medical condition of the individual, then they would not be entitled to benefits. But if you're displaying any individual symptom of COVID-19 and you have to miss work for about a week or so, then eventually you will be able to receive benefits for that week. But let me note that if someone is out of work for a week, let's say they can't work, and they come back the following week and they apply for unemployment after that week of unemployment, they are not going to get a check immediately. I'm sure you will probably get questions that there's at least a 3-week lag time from when you file for unemployment benefits before you certify and actually receive a payment. So, you may want to prepare your workers and let them know that, just because you're gone that week and you file for unemployment, you're not going to immediately get a check in the mail from the UIA. Those days are over. It's going to take some time. Eventually, they should get the benefit check, but it's not going to be for 2 or 3 weeks until after they had to leave the workplace. So I just want to make sure you know, so you can prepare your workers who are going to be off for a while. Another COVID-related change: an individual is not disqualified if they had contact within the last 14 days with a confirmed diagnosis of COVID-19. So if somebody has to quarantine because they had contact with somebody who tested positive and they are home for, let's say, 2 weeks as a quarantine period, they will be permitted to get unemployment benefits. They will not be disqualified for voluntarily leaving their job. You also can get benefits if you need to care for another individual with a confirmed diagnosis. The statute specifically states individual, so that means anyone, friend, family member, neighbor. If you need to care for someone who has COVID-19, and let's say you're out of work for 3-4 weeks because you have to do that, you will be entitled to unemployment benefits under the new law. Now let's go to number 5. If the individual has family care responsibilities as a result of a government COVID-19 directive. So if the school shut down and you need to go home and watch your children, you will be able to get unemployment benefits. And of course, I'm currently in the middle of a school shutdown in Forest Hills Public Schools, so I am familiar with that. That's one change that they made, so that if the school's shut, you are able to continue to get your unemployment benefits. Now, none of these COVID-related conditions apply if the individual is receiving paid sick leave, really any type of paid leave or paid disability benefits. You are not eligible. So that's going to include FFCRA benefits, anything. If anybody is off work and they're getting paid while they're off, they will not be eligible for unemployment benefits. That's specifically what it says under the statute. Also, the money that they make while they're off, whether it's PTO that eventually gets paid to them, any type of medical leave, disability benefits, that is going to be usually too much, and it will disqualify them from benefits anyway. So if employees are off on a paid leave, they have to take let's say 2 weeks off in quarantine, but they use PTO, they use some FFCRA leave, then they are not going to be eligible for unemployment benefits. All right, let's give some examples here of how it should work in the real workplace. So an employee leaves work for 1 to 2 weeks because he or she has fever or cough or shortness of breath. Do they get benefits? They do. That is specifically covered under the new act. You have symptoms of COVID. You have to leave work. You're gone. You will still be entitled to benefits. But you have an employee that's undergoing cancer treatment or recently had treatment and they can't go to work. They must quarantine themselves. Yes, that individual will be entitled to benefits. They are immunocompromised. They have a medical condition that makes them particularly vulnerable to COVID. So they are able to take time away from work and still collect unemployment benefits. If an employee needs to care for a spouse or a friend that has COVID-19, yes, they can take the time off work, care for them, and they will get unemployment benefits. Now, the fact that somebody would be eligible and able to collect unemployment benefits doesn't have any impact on any of your policies. So if you have to apply attendance points or things like that, you should still go ahead and do that. Make sure it's not some sort of protected leave where you can't do that. But otherwise, whether or not somebody is eligible and able to collect unemployment under these new laws doesn't have any impact on how you administer your normal day-to-day policies, attendance, medical leave, those types of things. Still keep following your own policies. That is completely acceptable. All right, so a school shuts down for 2 weeks. Employee needs to stay home to supervise their children. Does that employee get benefits? Yes, they do. They would be eligible for benefits. How about if the school shut down until the end of the year? Sure, still. You would be eligible for benefits. Now, of course, all of this depends on whether or not they are otherwise eligible for benefits. If they used up all of their benefit weeks, then they would not be able to get paid. If they did not make enough money during their previous work history, they would not be monetarily eligible. All those things must be satisfied. But under the new law, the fact that they voluntarily left for some sort of COVID-related reason is not going to disqualify them. We got a good question here from Nicole. Would the employee be required to use benefit time first before being eligible in employment? That is an excellent question. And the answer legally is no. They wouldn't have to do that. If they can continue to bank that benefit time, that is absolutely fine. They can do that. However, you should follow your normal policies. If you require people before, if they're going to take some sort of leave, if you require them to use their paid time, which many employers do, it's in a lot of employee handbooks out there that I've reviewed over the years, then if you require them to use PTO, you can require them to use PTO. And right now, they're probably going to want to use their PTO due to the low unemployment rate. It's only $362 a week. Chances are, if they get paid through PTO, they're going to get a lot more money. But technically, no, you do not have to require them to use PTO. All right, so you have another example. Employee states they can't come in for 14 days because his or her friend just tested positive for COVID-19, and there was contact between them. Is that employee eligible for unemployment benefits? And the answer is yes, they would. They had contact with a confirmed positive case of COVID-19. They have to quarantine themselves for 14 days. They would be eligible for benefits. All right, let's say you have an employee who is out for 4 weeks, and when they're gone for 4 weeks, they're receiving both FFCRA, paid leave, and they're also receiving PTO. Are they eligible for unemployment? No, they're not. If you're receiving any type of paid leave, if it's paid, you are not going to be eligible for unemployment benefits. Here's a question that I get frequently about people who only miss short periods of work. Let's say you have an employee that works 3 days. They go home with symptoms. Let's say they have a low-grade fever, and they're home. They get tested. Your average test takes at least 72 hours, sometimes longer, to get processed. So they're off work for about 3 days. Eventually, they test negative, and they're able to come back to the workplace. So this is an employee who only missed a partial week. Is that employee going to be able to collect unemployment? And the realistic answer is probably not. That employee, during the 3 days that he or she worked, probably made too much money in order to qualify for unemployment benefits that week. In the state of Michigan, if you earn what we call 1.5 times your weekly benefit amount, for most individuals, it's $362 a week. That's what most people qualify, which is the max. Some people it's lower, like 300. But if you qualify for the max, which is 362, anyone who earns $543 gross in any given week is not eligible for benefits that week. That income, when it's earned, it has to be reported. It doesn't matter if you've actually been paid for that. It has to be reported to the agency. And once it is, that individual will get an absolute zero. You are not entitled to benefits. So if you've earned less than 1.5 times your weekly benefit amount, then you will be entitled to something, but it'll probably be pretty small. Your benefits that you receive from the unemployment agency are reduced based on how much you earn during that week in unemployment. So generally speaking, if somebody misses only part of a week, they're probably not going to be able to collect any benefits. If they do, it will be a smaller, reduced benefit. All right. Let's say we have an employee who has no symptoms. They're not immunocompromised in any way. They have no contact with any positive individuals. The employee is just simply scared to come to work. I've seen this several times. Maybe you have 2 or 3 cases pop up in your workplace, and you have a couple of other employees that say, I don't really feel comfortable being here during this time. I want to wait until this blows over. I'm going to take a couple weeks of leave or a week of leave, and this kind of has me scared. Now, being scared to come to work in that situation is completely understandable. It is reasonable. But from an unemployment aspect, you're not qualified for benefits. You should not receive unemployment benefits for that week. If you have, if you fall under the statutory criteria related to COVID, you're good, but simply being scared to come to work, that is not a qualifying reason to get unemployment. So that individual would be disqualified, and the unemployment agency has actually said this itself. It has made this statement. Again, it's reasonable under the circumstances, but the employee should not expect to receive unemployment. We'll talk a little bit about work-share programs. Generally, if you have not looked into these programs and you are considering some types of layoffs, you might want to take a quick look at it. On the unemployment agency's website now, there's some really good information. They have a toolkit, a work-share toolkit for employers that answers a ton of questions that employers have. But generally speaking, how these programs work is instead of completely laying off groups of employees, what you do is you reduce their hours and their pay. So you take somebody, you were going to lay off 25 people, but instead you take that 25 and you reduce their pay by 50% and their hours by 50%. And that way the company can save money, but you also keep those 25 people engaged in your workplace. These programs are very good for retaining your employees. If you have hiring problems, you might want to consider work-share instead of layoffs. Now, they also have their limitations. They're less flexible. While you have a work-share program in place, technically anybody that you designate to be part of that work-share unit cannot be laid off. Also, you must maintain benefits, so you will still have that expense as an employer. But if you can utilize one of these programs, if you can make it work, just about all the employers that I spoke with has really, really liked them, that they have been very beneficial. Now, one of the main reasons employers did this back in March and earlier this year is because people who were in that program, they were able to receive a reduced state unemployment benefit, and on top of that, they got the $600 from the CARES Act, the additional $600. So that put a lot of workers in a position where, although they were making less money at work from the employer, when you add the $600 onto that, some of them were even making more money. And it was a really good program for both the employer and the employee. It prevented layoffs. They also got reasonable pay during that time. But of course, That additional money is gone now. So there's not the financial incentive to do it, but I still recommend you look into those because they are a great way to keep your workforce engaged and retain your employees. Now, it should be noted that you can have multiple work share plans. You can have a group of employees that you take down to 50%. You can have another work share plan for a different group of employees that you take down to 25%. And you can even have another one. You just need to have a minimum of 2 employees in the group, and you have a work share program. So if you want to reduce different groups, different amounts in their hours and pay, you can do that. You can create multiple work share programs. And if anybody is considering this and you're going to apply for it, make sure you do so through your MIWAM account, which is your online unemployment account. Basically, right now, that's the way that I recommend that any employer in the state of Michigan communicate with the unemployment agency. Faxing things in, some of those things are being processed. Many of them aren't. Mailing things in, I think we went a long time at the agency where they didn't read a single piece of their mail. Allegedly now they are caught up on their mail, but the most reliable way to communicate with the UIA, if you're an employer or an unemployed worker, is to use your MIWAM account. That is the best way. Most of the agencies' employees are working remotely now, so communicating with them electronically through the MIWAM account is the absolute best way to do it. And if you're going to create a work share program, you can do that all through your MIWAM account. Now, fraud and identity theft. This has been a major problem. A major problem in the unemployment agency, and it started basically right after the pandemic hit. There's a record number of identity theft claims. Chances are someone in the audience here who may have even been working throughout the pandemic probably had 1 or 2 or 10 unemployment claims filed in their name. They are absolutely everywhere. There is epic levels of fraud and identity theft in the unemployment system. My recommendation is keep an eye on your UIA 1136 accounts. You receive weekly charge statements. Those can be found on your MIWAM account. Sometimes HR professionals don't have access to that. You may have to speak with someone in finance because they pay the taxes and they handle those types of things. But if you look at those weekly charge statements, you get them on a weekly basis. It tells you who you're being charged for unemployment. If you see names of current employees, ex-employees who haven't worked for you 5, 6, 10 years, names that you simply don't recognize, make sure you protest those. You need to protest those, and you need to report the identity theft online. Also, take a look at your UIA 1575 monetary determinations. Employers went a long time without getting a lot of those. My understanding is that the UIA, when somebody files now, is actually sending those monetary determinations out. Employers are getting those in the mail. If one doesn't look right, if you say, wait a minute, I just got an unemployment claim for Bob Johnson, Bob's working over there. Take a look at that. Make sure you speak with Bob and let Bob know that there's potential identity theft here. And the identity theft should be reported both by the employer and the employee. It's very important. Online reporting of identity theft and fraud is the absolute best way to do it. You can go to the UIA's website. You click a box simply that says report identity theft. It gives you the option to report it as an employer or an employee. And if the employee reports it, which he or she absolutely should do, they're going to need to submit a UIA 6349, which is a statement of identity theft. That is absolutely the best thing to do. Here is a copy of the form. They need to fill that out and then make sure that that gets sent to the UIA. And the best way to do that is through the UIA's website. Employers can also do this on their MIWAM account and report fraud. So keep an eye on your communications from the UIA, both your weekly charge statements and your monetary determinations. If you see something that doesn't look right, maybe a current employee, report that. Also talk to the employee. Back in the day, I used to handle a lot of unemployment fraud where employees would continue to collect unemployment, let's say after a 2-week shutdown. They would continue to certify and get benefits, and they were committing fraud. Most of the cases now, the employee is not actually doing anything wrong. Most of the time, it is an identity thief who has filed a claim under the employee's name and Social Security number. So let's not immediately jump to the conclusion that the employee is doing something wrong. If you receive a claim for Bob Johnson and you look over and you see Bob Johnson's working here and he hasn't missed any work for the last 6 months, then let's not immediately assume that Bob is committing some sort of fraud. It's probably identity theft. Now, what is the agency doing to combat this? That was a question that we received before the presentation. The answer is that they heightened their identity verification requirements. So things like driver's license, Social Security cards, things like that need to be provided before a claim will be processed. And I think that is working now. That has rooted out a lot of these claims. The UIA is still digging out of hundreds of thousands of these claims. But they're starting to get denied, and they're starting we're starting to dig our way out. So I think what the agency is doing is working. It still is going to take time, and we are going to continue to see these claims. All right, let's talk a little bit about employer charging issues. Generally speaking, with unemployment, you're either a contributing employer, which means a tax-paying employer, or you're a reimbursing employer. And reimbursing employers have to pay dollar for dollar for every benefit that is charged to them. Tax-paying employers get benefits charged to their account, and it affects their tax rate. And that tax rate, if that changes or goes up, that's going to raise your taxes that you pay on all of your employees the following tax year. So we've had issues. So when it comes down to it, whether you're a reimbursing or a contributing employer, how your account is charged matters. It does. It can raise your taxes, or it can cause you to pay out a bunch of money in reimbursements that you shouldn't be forced to pay. Now, some of the charging issues, let's talk about the first big one here. Under 3 of the executive orders and the new law, what they state is that benefits that are paid to claimants that are, quote, laid off or, quote, placed on leave of absence in response to COVID-19 must not be charged to employers. Those benefits must be charged to the agency's non-chargeable benefit account. Things that are charged to the non-chargeable benefit account, we don't have to reimburse, and they don't affect our taxes in any way. So this is good. I think both what the governor and the legislature meant when they passed these laws is that we don't want employers charged for anybody who they had to lay off or place on leave of absence in response to the COVID-19 pandemic. Now, that should legally apply from March 16th through December 31st. They must be charged in the non-chargeable account, and employers' accounts should not be charged. That is not happening. Employers are still being charged for COVID-related layoffs. This could increase your unemployment taxes. It could increase your current reimbursement liability. If we have any reimbursing employers on the phone, if you've had layoffs, I bet that your bills have been very, very big that you've been receiving on a quarterly basis from the UIA. So how we're getting charged is a very big deal. Will the UIA fix this problem on its own? It might. I don't know. I haven't heard. I know employers received electronic communications from the UIA. I think it was back in mid or late July that essentially said, rest assured, we know that you shouldn't be charged. From what I understand, some employers have received credits, but then those credits have been taken away. Other employers have received nothing, and they continue to be charged for everything. So it could be a big deal. So you should take action if your company, one, has a substantial amount of payroll. If your unemployment insurance taxes on a quarterly basis, and you may have to talk to finance about this, if they're large, then you want to make sure that you are not getting charged for benefits that you shouldn't get charged for, because it's going to increase your taxes. And then in 2021, you're going to be paying a lot more in unemployment taxes than you probably should. Or if you're a reimbursing employer and you've paid very large bills in the second and third quarter, and if you had any layoffs whatsoever, I guarantee you that you have, you want to make sure that you are not getting charged for benefits that both the legislature and the governor said you should not get charged with. Hopefully, the UIA will fix this by the end of the year and get everything straightened out. I'm not so sure that's going to happen, so we need to make sure that we keep an eye on these things. And if you have charges for individuals who were laid off or placed on leave of absence due to COVID-19, you may want to consider protesting your weekly charge statements or taking some sort of action to make sure that your account gets credited for those individuals' benefits. All right, so consider protesting. Keep an eye on your 1136 weekly charge statements. That's where you will see all those. So if you're seeing a bunch of people, when you laid off 20 or 30 people back in March, and you're still getting full charges for all these individuals every single week, you may want to consider protesting. One good thing is, under the new law, you have up to 1 year from the date that you were charged for the benefit to protest. So if you were charged, let's say back in March, for benefits for an individual that you shouldn't have been charged with, you can protest that all the way up until March of 2021. Previously, you had 30 days. You get that UIA 1136, you have 30 days. If you don't protest that, it's final. Technically, even if it's fraudulent, even if it's wrong in any way, if there's a mistake, that is final legally. Not so anymore. You have up to a year to charge. So my recommendation is take a look at your 1136s. If you're getting charged for individuals that were laid off or placed on leave of absence, you will want to protest and take some sort of action. All right. Now, reimbursers, this is a big issue that I've noticed. Under Section 2103 of the CARES Act, reimbursers should receive a 50% discount on their reimbursements to the agency. So reimbursement is going to cover public employers, governmental employers, schools, as well as nonprofit elective reimbursers. If you've been approved as a reimbursing employer and you're a nonprofit, you are entitled to this as well. So on all benefits from March 12 through December 31, you should be getting a 50% discount. So if you had layoffs and you're receiving big bills and you're a reimburser and you are paying those bills, please be aware, under Section 2103 of the CARES Act, you are entitled to a 50% discount. But I bet you are not receiving that. Most reimbursers that I have dealt with are not receiving this discount, and it's very important. They're still getting fairly fully charged, and they're writing big checks to the unemployment agency on a quarterly basis. And the reason that is happening is initially when the CARES Act was passed, that 50% discount, the Department of Labor issued an unemployment insurance program letter that said the way that this has to be processed is they have to pay 100%, the reimbursing employer does, and then the state will go to the federal government, get 50% of the money back, and then issue a refund later. That is not what they intended when they passed the CARES Act. They wanted cash-strapped reimbursing employers to get an immediate relief, 50% relief. So once the Federal Department of Labor came out with that unemployment insurance program letter, Congress went to work and they passed the Protecting Nonprofits from Catastrophic Cash Flow Strain Act of 2020. That is a mouthful, but that is actually what they named this act. And so what that stated was that basically from March 12th through August 3rd, states can choose their method. So they can charge you in full, then get 50% of the money back, then issue you a credit to your account, or they can charge you 50%. Now, by the time this act was passed, most everybody had already been charged. So I imagine that most states charge everybody in full, and then they're going to get a 50% refund. But under that new act, as of August 3rd, you must be charged 50% of the state benefit. So if you have a max benefit employee that is on unemployment after August 3rd, they receive $362 a week. That's what the charge would be, the state portion of it. You should be getting $181. That's what your UIA 1136s should say. $181 a week maximum for the employees. So you should take a look at that. Take a look at your 1136s and see if you're actually getting charged in full. Now, again, will the UIA fix this on its own? It might. I have no knowledge that that is going to happen. I have no idea what they were doing. I haven't been able to get a response from the agency on this, but it could be that the agency has elected to charge all reimbursing employers in full up through the end of the year. And then after they close out the year, a credit will be issued to all those reimbursers. Technically, under the new law, they're not allowed to do that. As of August 3rd, they have to charge you 50 cents on the dollar for every unemployment claim. So what I recommend you do is keep an eye on your 1136s. Make sure that you were charged 50 cents on the dollar after August 3rd. If not, protest. You should still, I recommend that you still pay your third and fourth quarter taxes under protest. Let them know there's a way when you pay those through your MIWAM account where you can pay those claims under protest. And then I would file protest saying, I want 50% of my money back. Whatever you should do, you should make sure that by the end of the year, you only end up paying 50% on all benefits charged to you from March 12th through December 31st. All right. With that, you have my contact information here. Feel free to give me a call with any follow-up questions. My email's there. Feel free to email me. And I would like to thank everybody for attending today. We appreciate you spending your time to listen to me talk today. If you have any follow-up questions, please contact me. And otherwise, stay safe and have a good rest of the day. Thank you.